Numbers 136 through 143, matter of County of Chemung against Shah, and 7 other related cases.
Good afternoon, Your Honors. I'd like to reserve 3 minutes for rebuttal.
3, sir?
Yes, sir. These cases concern the 2012 amendment to the Medicaid cap statute, an amendment that was intended to clarify that reimbursement for overburdened expenditures that arose before 2006 are not available under the new cost-sharing system. Now, there are several issues in the case, but I'd like to begin by focusing on why this amendment treats the counties fairly. This new...
Before you go there, counsel, does your interpretation or your argument that the counties are not persons and therefore have no due process protections eviscerate the exception related to the proprietary interests?
No, Your Honor, because if a county can satisfy that exception, it can challenge a state law under a variety of other constitutional provisions.
Well, what would those be?
Home rule?
No, but home rule is a separate exception.
No, well, yes, that is.
I guess I'm asking, isn't the proprietary interest in and of itself, by its nature, about due process protections? Isn't it so aligned that you cannot argue it the way you're arguing it?
No, Your Honor, because you're talking about the issue of whether capacity and personhood are the same thing. The case you could look to is County of Rensselaer versus Reagan. The counties or the municipalities challenged a state law under Article 5 of the New York Constitution. The comptroller was charged with sort of seizing what was alleged to be county funds. The county had capacity under the proprietary interest exception, and it was successful in its challenge to that law under Article 5 of the New York Constitution. That doesn't eviscerate the proprietary interest exception. The county simply has to rely on a constitutional provision other than the due process clause. My argument there is...
But I'm not really understanding why that's so. I mean, in this case, they're arguing that they have a particular interest in this money that they gave to the state, which everyone acknowledges they're not chargeable for that money in the sense that under the statute, that is not money that is part of their local share. They pay it with the understanding that they will get reimbursed. They're claiming, we gave that to you under the statute with the understanding that that would be reimbursed. And you refuse to reimburse, they claim, right? They claim that there are monies that we paid that have not been reimbursed. We have an interest in that. It went into a specific fund, into the comptroller's fund, and we have a right to that money. Why doesn't that fit specifically under the proprietary interest exception? Why doesn't that allow them to make a claim that if you don't allow them to seek reimbursement, you're denying them due process?
Well,
and they have a right to do that.
That exception would come into play while the old cost-sharing system was in effect, while they had statutory rights. The legislature comes along and changes the system. They don't have the right to challenge that decision by their creator to reallocate the costs of a governmental program. So that
prospectively, right? Their argument is, but we've paid over the money, so now it's due. The challenge is not the state can't make a decision saying, moving forward, this system is one that we no longer wish to pursue. We want to change the allocation. Now, that's not this challenge. This challenge is, I gave you the money years ago, you owe me the money, and I expect to be paid for the money, and at a minimum, I have the right to make a claim for this money.
The error behind that argument is that somehow there was a dividing line. The old system governed expenditures that were incurred before 2006, and that the new system governs expenditures incurred after 2006, and that's simply false. The new system is a cash-based system where you're required to pay a fixed amount. And the problem with paying this money is that if the payment is made, the county is not meeting its obligations under the current reimbursement system. So in other words, if you're a county and your current obligation is to pay $10 million there's a $2 million claim that you make from the year 2000 before the cap system went into effect. You're submitting that claim to the state today. If the state pays that claim today, you're not paying $10 million, your cap obligation, you're paying $8 million, which is less. And it is true.
Well, they could pay the 10 million, you could reimburse them for the outstanding money. I know you look at that as a deduction from the 8 million, but you didn't do that under the old system. You never saw that as a deduction from the local share, because it's not money that they are really being charged for, right? It's sort of a pass-through, pay us the entire, it sounded to me, you can correct me if I'm wrong about this, it's an administrative convenience, and you happen to make some interest off of it. You define the local share, right? The local share, you tell them what the amount is. Again, correct me if I've misunderstood this process under the old system. They pay it, and then the Department of Health determines which of that money is in this reimbursement, right? The overburden reimbursement, which is to say money that they never really owe you, right? And you pay it back. And once you identify that, state doesn't have a choice not to pay it back. On the statute, you have to pay it back. Did I misunderstand the old process? I understand your arguments about what Section 61 does and those other amendments, but have I misunderstood that old process?
That's correct, and it is true that there was money that wasn't identified and paid back to the counties. They lost that. I will admit they lost that when the new system came into effect. But what they got in return was a new system that saves them billions of dollars, far outweighing whatever they're losing in these old reimbursement claims.
But did they only lose that because they were too late to send in those claims? Not because of the nature of the claims themselves? Isn't that what this boils down to?
Well, yes, as it turns out, the claims came in after the system changed. And I'll accept for purposes of argument that they're not at fault, although they are at fault for the delay in submission of the claims. Let's just say they're not at fault for the fact that we took their money and didn't give it back to them. I readily acknowledge they're losing a couple $100 million in money that would have been paid to them if the system had remained in place. But the system changed, and the change in the system simultaneously did a number of things. It cut off the right to this old reimbursement money, but it protected them from old liabilities. That's one of the trade-offs. And the big trade-off is the new system saves them billions of dollars. And their obligation under the current system is to pay their cap amount.
Counsel, going back to the old system, just so I understand, I think the third department in one of the cases, or maybe both of them, said that the state is obligated to, or the Department of Health is obligated to review the records of the counties and pay monies that the counties are due, that are owed to them. And what I'm concerned about is that without having the counties having to make a claim for reimbursement, or is it, you know, sort of sua sponte, the state has to look at records and decide that there's money owed and then pay it?
Well, according to the third department's tortured interpretation of the 2012 amendment, you're right that the court seized on the fact that the 2012 amendment makes reference to claims submitted by social services districts. And it reasoned that, well, the counties didn't have any obligation to submit those claims. The amendment didn't terminate the underlying obligation. So not only are we going to extend the grace period 3 years, but we're going to grant mandamus relief. In other words,
What I'm really asking, though, is does the statute require reimbursement without first a submission of a claim? Or does the state have to just look at whatever the counties submit to them without making a claim, whatever records, and I imagine the counties submit a lot of records concerning Medicaid, and the state has to look at those records and say, well, this is a overburden reimbursement and it's due to the county.
under the old system, the health department did have this obligation to make sure that the counties contributed nothing to the overburdened patients. The health department met that obligation in 2 ways. It had the quarterly reviews 4 times a year. It gave the counties the money it thought it was due. It realized because of the size and complexity of the system, it might have missed some of the reimbursements. So it had a regulation that has the force and effect of law that says if you think we missed some of the reimbursements to which you were entitled under those quarterly reviews, submit a claim. So really, the third department is wrong in that if the counties wanted more money beyond what they got in the quarterly reviews, they had to follow the regulation and submit the claims. This goes to the issue of whether the 2012 amendment terminated the underlying obligation. And it obviously
Can I just
did.
ask, under the regulation, was there a time limit by when these claims had to be submitted?
Yes, but in prior litigation, the appellate divisions rejected our argument about that time limit, so there really winds up being no time limit to
Well,
submit the
what was
claims.
the time limit?
It was a year.
It was 1 year from what,
From the-
accruing as of when?
I believe it was from the date of service. I might be mistaken on that, but there was a time limit. We lost on that, so there winds up being no time limit.
Can I just clarify one other thing? I'm sorry, in
Sure.
your explanation, I'm just trying to make sure I really understand this process. Based on what you've just said, I had read the briefs and the record to mean that the DOH and the state took the position that they complied with the statute by reviewing the documents. They paid what they believed were accurate amounts in reimbursements. You created this claim process in case they thought there was an error. It was not that you acknowledged an error. I understand your point where you're saying, okay, maybe anyone can miss something. I get that point. But it was not that you were affirmatively saying, our process, our initial review process, we affirmatively review this and cut a check, or however you pay them, is riddled with problems. It's not that you took that position. It's that you created a system by which if they thought you had made an error, they had the opportunity, based on documents that you provided and documents they had, to seek additional funds.
Precisely.
But you always started from the position, we've complied with the statute, we've paid you.
Yes, but all of this goes to why the statute is worded the way it is. It makes reference to, notwithstanding Section 368A of the Social Services Law, the provision that created the overburden obligation. The obvious intent here was to terminate or clarify that overburden reimbursement had been terminated when the new cap system went into effect. The reason why that's fair is because we can't submit any additional old bills to them. They can't submit any additional claims to us. They pay their fixed amount.
Before you lose your time, as I understand it, one of the main arguments here is that the counties are creatures of the state, and that they have certain powers as counties. But in situations like this, it's the state that makes the determinations as to who, what, when, and how all of these things are done. Because if I remember right, when the mainstreaming of psychiatric patients kicked in, that's when the state felt it had an obligation to cover them and said, so if you've got these people and they're costing you money, because they used to be institutionalized, we'll reimburse you for that. But they could have said nothing, and the counties would have just had to handle this. And so each one of these things is the state orchestrating how this thing is going. And your point is that at some point that one ended, whether it was a mess or whether, whoever was doing what to whom. We're starting new. This is it. We're holding you harmless on any future expenses, but these are gone.
That's exactly it, Your Honor. I mean, we recognize that when the system changed by switching to this system where they just pay a fixed amount that covers expenditures regardless of when they accrued, there would be a loss of entitlement to this old reimbursement. But they got the billions of dollars in savings, and they got protection from old liabilities. That's the trade-off. That's why this is fair under a vested rights analysis, assuming that you get there.
Chief?
Yes, of course.
But going to Judge Piggott's point early on the counties and really what's a capacity issue, right? Didn't you waive that argument?
Oh, sure. The capacity issue is waived, but the issue is whether personhood and capacity are different doctrines or concepts. And capacity is a procedural requirement. You have to have authority to sue. So under the proprietary interest exception, they claim an entitlement to a specific fund of money. If they could have sued when the old statute was in effect, they have authority to get in the courthouse door. Now, do you have entitlement under the constitutional provision that you claim is violated?
That's the Fourth Department reasoning, right? And I'm having trouble distinguishing those two things in that decision.
I don't know where the confusion comes from is because they're related in that the rationale for why you don't treat a municipality as a person for due process purposes is very similar to the rationale behind capacity. You're not a person because we created you, you're an it, to carry out governmental functions. So that's why you will see citations in capacity cases to these old personhood cases from the Supreme Court. It's undisputed that as a matter of federal constitutional law, municipalities aren't persons. Most states think that they're not persons. And this court, in the Jeter case, reached that conclusion because the court said that the municipalities there lack the substantive right to sue, citing the old Supreme Court personhood cases. They say that's a reference to capacity, but that makes
But it
no
also
sense.
made a reference to an exception that fits under the capacity as we've otherwise described it in our jurisprudence. So
Yes.
they do have some legs to this argument.
I agree there's some ambiguity in the decision. Like, you're not a person, so you can't sue under the Due Process Clause. And in addition, you're not alleging that the state is forcing you to violate federal law. That's why that sentence is found there. The reason why they're not persons and the rationale is, what's the purpose of the Due Process Clause? It's to protect the government from abusing people and taking their property. It's not to allow one political subdivision created by the state legislature to go to court and say, we don't agree with the new cost-sharing responsibilities, or we think that we should have...
And that's where I have the difficulty. That's not, I don't see the claim that way. I see the claim as, we paid money that under the statute is not money the state is truly owed because it's an overburden reimbursement. It should not have been. It is not part of our local share. That's what we want reimbursed. You can change the allocation. We can't challenge that. We can't dispute that, agree with that. But that's money that we've already turned over under the prior regime, which ensured that we would get paid, and that's where our interest is, and that's where this court's jurisprudence has said, when you've got a proprietary interest, yes, you are correct, they acknowledge it, they concede it. The general rule is they don't get to sue the state. They don't get to lay this claim against the state. But when there's that proprietary interest to a specific fund, which it looks like what they have here, that's when they get to come in the door. They may not win on the merits. On the merits,
Right.
you may be absolutely right, not because of personhood, but because of the merits. But they get
Yes.
to make their claim. That's all they're
Yes,
saying.
they can make the claim, but the answer is, guess what? You're not a creditor and we're a debtor. You're our creation that we created to carry out a governmental function. What you're claiming to be is your money is tax revenue that we, the state, authorize you
But
to
isn't that
collect.
true under the proprietary interest exception?
That will work in other contexts. In this case, it gets them to the courthouse door. The claim fails on the merits because they're not a creditor who has a claim to money. There's an ongoing financial relationship. Tomorrow, we could raise the cap to more than offset whatever we would pay them in these old overburden claims. This is why this is all so silly. I mean, it is a reallocation of financial responsibility. It's not a creditor trying to make a debtor pay some
So
money.
do you say their local share was not county funds, it's always state funds?
They're not a creditor in the sense that you can bring a due process claim.
No, but are they county funds versus state funds?
They do not have, I would dispute this proprietary interest argument, but I've waived it, so I don't want to burn up time on it. What their claim, proprietary versus governmental, this is the operation of a program to provide medical care to poor people. The money that they're paying is from tax revenue that they have no power to collect unless we gave it to them. So they're not, we didn't take their money, we
But you seem to be
reallocated.
saying, Mr. Palladino, earlier, that they could get at those funds in some other way, not under the Due Process Clause, but they could go under some other article of the Constitution. I think you mentioned Article 5.
I don't think anything works here. I'm just trying to
So there
rebut
isn't
the
any other
argument
thing.
that the exception is dead if somehow they're not persons. If they had a violation, if we were using the comptroller somehow, like in the Reagan case, to do our bidding, and we were assigning him an administrative function, it could be knocked out under the Article 5. Nothing works here, because really, this is just the government reallocating the cost of government, giving up or wiping out old liabilities.
Although you waived this exception, you're saying it doesn't matter because they can't enforce this.
It's an essential element of a due process claim that you be a person. And every federal court and all the other state courts go this way. And again, the rationale is we are not protecting one part of the government from trampling on another government. It's there to protect people who actually do have a property interest that would be recognized. This isn't like Alliance of American Insurers, where the insurers had an interest in a fund and the state took that money away. This is the government saying to the government, yeah, we would have given you that money back, but guess what? Instead of giving you back a couple $100 million, you're going to save billions of dollars. They're trying to have it both ways.
Except that there was a statute that specifically said you have to return this money.
And
Isn't that what makes it different here?
And while that statute was in effect,
Yes.
that proprietary interest exception could have been invoked if the health department.
I got it. So then they
Right.
have claims up to 2006. Now the question is, can they, a decade later, seek these claims to be paid?
Precisely, and on the merits, I mean, you don't have to, I'll be very happy if you don't go anywhere near this personhood argument, that's because it has some broad implications, and I can understand why you would be concerned about them. The path of least resistance here is to hold that this amendment or this system treats the counties fairly because they lost a couple $100 million, they saved a hell of a lot more, pardon my language, a couple $1 billion in return that far outweighs what they gave up, that's eminently fair and reasonable, and that's the narrowest ground on which you can resolve this case. I see I've gone well beyond my time, but thank you for
Mr.
allowing me to
Palladino.
answer your question.
Thank you. Counsel?
Thank you, Your Honor. May it please the Court, Christopher Buckley from Whiteman, Osterman, and Hannaford, on behalf of the counties.
If they can allocate funds at any time, how do you have any existing claims?
If you could just give me one moment, Your Honor. To the extent we have appellants here, could I reserve rebuttal time, Your Honor?
Yes.
Okay, 3 minutes, respectfully. Your Honor, what we're talking about, and it goes to, I believe, a number of the questions regarding the capacity doctrine in the first place. The capacity doctrine is actually a balanced approach that looks at the municipality's claim. In other words, the municipality's right is dependent upon its claim. So as Your Honor just pointed out, if the municipality's claim is based upon political power, allocation of governmental functions, allocation of resources in the future, the claim's not going to be recognized. It absolutely won't, and it'll be dismissed. And that's manifest in the Jeter case, in the City of New York case, and the Black River case, all of which the state relies upon. But it's different when we're talking about a proprietary right. When there's a proprietary right, now a municipality does have the ability to bring a
They
constitutional
don't have to
claim.
pay this. I remember from my county attorney days, when MMIS and IFMIS came in, and up until then, the counties were collecting the money, and some of them relied on the float, and then would send the money down to Albany after it had been collected periodically. The state ended up getting a different system and said, from now on, we're collecting the money.
On a weekly basis.
And we lost a ton, we being Erie County, as a result. No, we didn't have any, we sued them. And who are you? This is what they do. This situation seems to me to be similar. There's a kettle of soup that we're giving people who are in need. And what they've said is, we've added to the problem that you have, because we're releasing these people from the psych centers, and now they're mainstreamed, and now they may end up on your docket, and so we're going to reimburse you for that. At some point, they say, we're not doing that. It's the same kettle of soup, but guess what? We're not going to reimburse you for that. And it's aggravating, but I don't know that you have anything to say about it, do you?
Absolutely. Going forward, Your Honor, that's a political question. That goes back to it's an allocation of political power.
But it's not proprietary. My point is that it's a state obligation. They could come in and say, because I think some counties say, all of our real property taxes are going to Medicaid. All of it. We're living on our sales tax. I think that's true, up in my neck of the woods. Governor Palladino can come in and say, from now on, we're doing all the real property tax. You don't, because we're taking it all. There's not a darn thing you can do with it.
This is different, Your Honor, because here what we had with the statute, 368AH, was a 100% guarantee that the state's going to reimburse these counties. We're going to take the money from you, and then at some point in the future, we're going to reimburse.
Counsel, where do you read that in the statute? That's what I was getting at with my question to Mr. Palladino. Where in the statute does it say you have to be reimbursed, and under what sort of circumstances? Is it
There
you
are
have to make a
no
claim.
circumstances, there's no limitation, Your Honor, placed on the obligation. All the statute says is that the social services districts, is what they're called, will be reimbursed 100% for payments made on behalf of these particular patients. That's all it says. And further, it doesn't say that the counties have to submit claims in order to get this money back. In the third
But
department...
that's kind of the point. I mean, it was just this big, I don't want to call it a morass, but I mean, it's just the way government seems to work. And you raise a good point when you call them social service districts, because they're not even counties. And if they wanted to say we're dissolving all the social service districts and any money that was due and owing to them is no longer due and owing, you'd be stuck.
Going forward, Your Honor, we would not be stuck based upon transactions that are already complete. And that's the problem, because what we're talking about is if the state's construction of this statute is credited, what we're talking about is a statute that is baldly retroactive. It's retroactive in the truest sense of the word because it takes completed transactions and an obligation tied to those completed transactions, and it doesn't just impair them, Your Honor, it eliminates them.
But isn't the point there that they eliminated them? One, I have some trouble with the proprietary interest, because this isn't the Alliance of American Insurers case, which one was an insurance company suing over a fund that was specifically designated and kept separate from the general fund with revenue from these companies to cover certain liabilities, right? So here you have money that's just going into the general fund of the state of New York, right? With a promise from the state under the old statute that we will reimburse you for certain things that you spend, but that we are ultimately on the hook for. You submit these, we will pay you. At some point, the state decides we're going to do that anymore, and we're going to change that, so this is your deal going forward, which takes into account that we're no longer going to reimburse you for these expenses, but provides you with this other benefit, which is equivalent or better financially for you than what you would have been owed under the old system. Why can't they do that?
Let's take a step back first, Your Honor, if we could address the proprietary interest exception. I don't believe the money is placed in a general fund. I think according to the state's affidavits that are in this record, the money's placed in a special bank account. That's the hallmarks of the proprietary interest exception. It's a very narrow situation. Based upon the state's admission, that's what we have here. Further, this issue was already addressed by the third department in Croscott v. Perales, where the court held the municipality, in fact, has a sufficient proprietary interest in overburden funds in order to
We
bring
never held
challenge.
that.
I understand that this court did affirm that decision, the third department's decision there. So I would argue that there's no question that we satisfy the proprietary interest exception, but even further, what we're talking about is capacity, and capacity, as the state has conceded, was waived.
Can you straighten that out for me? You say there's a special bank account. As I understand it, what you were doing, what the counties were doing, was paying money out. In other words, you've got an individual who was formerly in a psych center, let's say, and now he's on the street, and you've got to pay for him, and they say, we will pay for this, we'll reimburse you for it, but you're paying it. That's why you have a bill.
That's not how it worked, Your Honor.
Well, wait a minute. Now, it's because I understand it. What you want, you're going to the state saying, you owe us money because we paid money out.
No, that's not how it worked, Your Honor, and actually, the third department's decision, what we call St. Lawrence 1, has a good description of the process. The way it works is just on a weekly basis. The state took the local shares from all the social service districts, not just for overburdened patients, for all the Medicaid expenditures.
Oh, I see. Yeah, but isn't the point the same? In other words, they took it, but had they not, you would have been paying money that you would then have said, you've got to reimburse us.
Yes, but I think we would have a much harder time showing the proprietary interest
Exactly,
exception.
but it's the same thing.
But they're taking our funds and placing it in the state's accounts.
I'm a little unclear. I thought the state paid the providers directly. Did I miss something
They
here?
did.
Did you pay the bills?
No, we did not pay the bills.
You never paid the bills?
No, we did not pay the bills. The state pays the bills, takes the money from us, and then says, trust us, we're going to reimburse you sometime in the
I
future.
don't say trust us. The statute actually says pay us.
Pay
So that,
us.
you didn't answer it before, but as I read 368-A1, at least 3 times it says shall.
Shall. It's mandatory, Your Honor, and it's a 100% guarantee. It's not 50%, it's not 98%, it's not the state gets credit for almost getting it done. Because the state's here, the overarching argument in the brief says, well, we paid a lot of the overburden, but it's okay that we didn't pay just enough, and it goes to Your Honor's
Yes,
point.
I just want to clarify your argument. Is your argument that you have full due process rights, or is your argument that perhaps you don't have full due process rights, but you have the rights, because you have this proprietary interest, to demand a claim against the state, because our jurisprudence has carved out this exception.
I would respond to that, Your Honor, by saying because this court has recognized the proprietary interest exception, it has implicitly recognized the municipality's due process rights.
Well, for that purpose, is there any way that you can protect that interest without invoking the due process guarantees of the Constitution?
Absolutely not, Your Honor. There's no other. The home rule doesn't protect these proprietary interests. There is no other way. And that's what's dangerous about the state's position today, both with respect to the personhood argument, the so-called personhood argument, and with respect to the merits of the claim. Because what the state is asking this court to do today is radically alter the relationship between states and local governments. Because what we'll have, if the state's successful today, what we'll have is that the local governments can no longer protect their property interests.
The counties.
Any local
No,
government.
because, I mean, the state rolls over counties and everybody else, and DEP and every other conceivable administrative work. I mean, I'm not a fan of this, but if you ever want to know how weak counties are, just call up any one of these administrative agencies.
I
and they're gonna tell you
understand,
how
Your
to
Honor.
operate.
It will be particularly felt by the counties who are, as we all know, operating, I think Your Honor pointed out, under dire financial circumstances right now. And so, again, the state now, what it's saying is, we can impose a financial obligation, and I don't think anyone disputes that. And we can say, counties, you front that obligation. But then, now, what the state wants this court to do is endorse the following, which is, even though there's a statutory guarantee, the state can choose not to make its funding. Or worse, as the case here, the state can just decide to say, we're not going to reimburse at all. And it can do it at any time, for any reason, and the counties have no
Well,
resources.
they can impose a statute of limitations,
And that's,
right?
they
Okay,
can.
so let's say the third department is persuasive, and we agree that it's really, you can read this to be a statute of limitations. I know you argued that also. This is a statute of limitations. Why do you get the extra 6 months? Why isn't it a statute of limitations that applies effective April 1st?
Because,
2012.
as this court established in the Brothers v. Florence case, when you are establishing a new limitations period or shortening an existing limitations period, as a matter of procedural due process, a litigant is entitled to some sort of grace period in connection with the change.
But you've known for over a decade. I mean, the claims are going back 20 years. So you've known for some time. Where is the procedural due process violation in recognizing the effective date as April 1st?
Okay. Your Honor, I don't think it's...
Unfortunately, being April Fool's Day, but let's carry on.
I don't think it's fair to say that the counties all knew that they were owed money. They still don't know. A number of them don't know if, in fact, they're owed anything, and if so, how much. They've never known. And there's a larger problem.
How is that? They're paid, right? The state sends a reimbursement, if it thinks you're owed a reimbursement, and then you have a claims process.
The state didn't set up a claims process. That's a fiction that's been presented
It's
to
in
all
the
the courts
regulation,
here.
no?
No, what happened, it's in a regulation because the counties, the few counties who realized what was going on, they said they had to figure out a way to get the state's attention. So they submitted claims under that
Well, they didn't
claim.
need to do a claims process, right?
Absolutely did not, Your Honor. And they all didn't know. They didn't have a reason to know because the problem is the state controls the information in the first place. It's the state's computer system. The counties don't have any say in this process whatsoever.
Are you saying you never had information?
Not until a number of these counties actually retained counsel and went and tried to obtain additional records. And the
Which
problem-
is years ago now, so the counties know about this, right?
No,
Years you've
it's
known
not,
about this.
it's not accurate, but there's a further issue, Judge, is because there's been no open window. And that's what the problem is here today. We're only asking for an open window. So if you want to run it from 2006 forward and say the counties knew,
But they kept winning.
they kept winning.
You sue and you keep winning, and this is years ago, and you know about these claims.
But Your Honor, the state is not saying, we're going to consider the merits of your claims and we're going to determine whether or not you're owed money. They're saying, there's these statutory impediments. The counties don't have the
But every time you won, they paid the claims.
only after they exhausted all the appeals, after the counties incurred tremendous
I understand,
litigation
but they did
expense.
pay the claims, and so the counties know they can get reimbursed.
Right.
Wouldn't you, especially if you're in financial straits, would you not move to get reimbursed by submitting claims. If
But-
you think any reimbursement that they've given is an undercount.
And it's still, it's a long process to determine whether or not this reimbursement's due and owing first. Because again, the counties don't have those records. And as you can see,
If you paid out the money, what do you mean you don't have the records? Are we not, I thought we cleared up that the county paid out the money and expected to be reimbursed, right?
the state
No.
just takes the money from the county before 2006 on a weekly basis, and then there's no records at the time
see.
the money's taken. And again, it's because if the counties had been paying the providers themselves, then certainly they would have a record. But it's the state who's paying the record, so the counties have no opportunity.
Well, they tell you
to
your
do-
share,
Pardon me?
right? They tell the county their local share.
Well, they take it, yes. And
Take
that's
it, I'm sorry, excuse my ignorance, take it how? Tell me what you
It was
mean by that.
electronic.
It's an electronic
It's an electronic
draft,
draft
okay.
on a weekly
Okay.
basis, and at the
Okay.
time the money's taken, there's no explanation where the money's going, and there's clearly no
But
explanation.
the
it's
county
going
knows it's for the
overburden.
local share.
Yes, they know for,
They know the amount because they know what's taken.
it's for a local share of all the Medicaid recipients,
But I
not
know,
just
but I'm saying
overburden.
they know their local share because it's a set amount that's taken from that county.
Well, it changes on a weekly, back
No,
then
no,
it
yes,
changed
I
on a weekly
understand that.
basis. Yes, they know that the
It's like
state's,
saying this week, the state took $1,000.50. Next week, the state took $2,030, right? You know the amount.
we know, yes, that there was a local share.
That's what I mean, the amount that's.
And don't you have a census of your overburdened population, or don't the counties have a census of their overburdened population?
No.
They do not.
They do not have a census. We're still trying to figure that out to this very day, Your Honor. We have no idea what the overburden population is, because the state has the records, because these patients came from state-run facilities.
Did you demand the records?
Oh, yes. If you look in the record, we had to bring FOIL proceedings, and then even then, we were only able to...
Have they refused to turn over records that the counties need to be able to determine a claim?
Yes, Your Honor, they have. And that's what we've been trying to do, that's what we were trying to do leading up to this litigation. And that's what the point is with the mandamus, is because we want this to be a final accounting. We understand that the state and the courts, they all need to move on from the overburden obligation. That's what the point is here, is to get the state to finally identify and calculate. We'd be happy to do it with them. We would do it cooperatively.
Thank you, Mr. Bucky.
Okay, thank you.
Counsel?
I'd refer Your Honors to pages 170, 171 of the first St. Lawrence record. We gave them reports when we did the quarterly reviews from which they could determine whether their overburden reimbursement was missed. It's using that information that they've been submitting these claims after 2006, the same information they had from 1984 to 2006. The FOIL requests and all the alleged misdeeds is us defending ourselves after the system changed, because the state is taking the position that the new system doesn't allow us to pay these
Well, what happened?
old claims.
Were they just not doing their job? Were they recalcitrant? I mean, why wouldn't a particular social service district say, you owe us this money?
I can't speak for why the counties didn't wake up until 2006. They hired Mr. Bucky and Ms. Rose Stormer, who realized that the system might have missed claims. But we gave them the information when the quarterly reviews were done. That's the very same information that they've been using to submit these claims. So the legislature could rationally determine, so much time has gone by, it's time to close the books on these old claims. Mr. Bucky keeps saying,
Counsel, let's say we approach this as, in some way, the way the third department did say it's a statute of limitations. Do we have to do the grace period? Is that what the jurisprudence requires?
well, no, that presupposes that there's a due process problem. Again, that's sort of why the path of least resistance here is to say this is reasonable under a vested rights analysis. There's no reason to rewrite this statute. And it's not a statute of limitations because the intent of the April 2012 effective date was to strike a balance, because there had been all this litigation. There were these judgments that had been entered directing the payment of overburden claims that had been submitted after 2006. The legislature was trying to clarify that these claims shouldn't have been paid since 2006, but we're not going to reopen these judgments and allow for the recoupment of the money. So that's why they just cut it off right on the effective date of the enactment. It wasn't intended to be some limitations period. But even if it were sort of looked at it
A
that way.
bar, it's a limitations bar. This is it, you can't submit any more, right?
Well, no, because it was saying you shouldn't have been able to submit them since 2006. Money, $17 million was paid between 2006 and 2012.
Yes, and now, effective April 1st, you can't submit any more of these pre-2006 claims.
Correct.
So it stops the submission process, which is, of course, the payment process, right? So all I'm asking is, like, is there any way to read or to interpret the cases based on this record so that the effective date is April 1st as opposed to requiring this additional grace period that the third department imposed?
Well, yes, because cutting off the reimbursement at that point in time is consistent with due process, either for lack of personhood or because it's fair. There is no due process concern, no basis on which to extend this limitations period. That's a sure, and given the fact that by the time April of 2012 came around, the youngest overburden claim was 7 years old, and the oldest claim was 28 years old. They had the information from these two reports that are described at pages 170 to 171.
You've paid off all the claims?
Pursuant
Any
to,
still outstanding? Pursuant to, I'm sorry. what were you-
pursuant to the judgments that had been in effect from 2006 to 2012, we paid those claims, roughly $17 million. There's still an unknown amount of additional unreimbursed overburden expenditures from before 2006. The only estimate in the record is $180 million. It could be many times that.
But all claims that were submitted by the effective date of Section 61, you have paid?
Yes,
Correct?
that's correct, Your Honor. And because we didn't want to open up those judgments, the legislature didn't want to disturb those judgments. That's why it made the amendment effective April of 2012 and not January 1 of 2006. That's why it really wasn't intended to be a limitations period. It was simply clarifying that those prior court decisions were wrong. This money wasn't supposed to be paid since 2006, but we recognize that money has been paid, and we're going to let the counties keep that. So that was the reason for the effective date, and the reason for the reference to the claims in the statute was because that was the process by which the counties got additional money not captured in the quarterly reviews. It was intended to terminate the obligation, because if it doesn't terminate the obligation, the amendment accomplishes nothing, because it just, okay, the counties don't have to submit claims anymore, but now on our own, we have to, under the third department's decision, go back to 1984 and unilaterally identify, calculate, and pay. That doesn't end overburden reimbursement. It continues just under a different process, and we know from the legislative history that that's not what the legislature intended. Thank you, Your Honors.
Counsel?
Just on the limitations period, actually, the state did in fact argue in front of the appellate divisions in the third and the fourth department that Section 61 is a limitations period. That's exactly what they said in the reply brief at page 6. So what the third department did is actually what I would say is take the path of least resistance. Didn't have to reach this issue about a substantive property right, a substantive vested right. What it did was take the state's argument and then look at the text of Section 61. Section 61, both the text and the history, talk about, in fact, claims. They don't talk about the obligation. So the third department rationally concluded that this is, in fact, a limitations period, credited the state's argument to that effect. Again, this is the path to least resistance. And as far as starting the grace period, well, let's take a step back. The grace period is required. It is required under this court's decision in Brothers v. Florence, because no one is disputing that the state failed to provide the grace period within Section 61. There's nothing in there. It's as soon as the law went into effect, the remedy was
Does it have to be
extinguished.
6 months?
Actually,
30 days?
Your Honor, 6 months is not enough.
I understand.
But the problem is, the state hasn't challenged the substance of the grace period. Hasn't challenged.
What's our review on that grace period?
It's abuse of discretion if it was challenged, Your Honor. It hasn't been challenged. The substance of the grace period, when it started, the length of it, that has not been challenged. It's been abandoned on appeal. That is not in front of this court. And what we would take the court back to is that the third department had to construe this as a limitations period, because that is what the state argued in the first place.
And as to the third department's holding on mandamus, is that in conflict?
Not at all, Your Honor. It's consistent with what the third department said. The third department didn't limit the limitations to claims. What the third department says, the limitation period applies to the county's remedies, all the remedies, and it goes to this fiction that, well, claims was the only way the state established to get this reimbursement in the first place.
But
That's
this is
not
what
true.
I asked the state before, what their position has been, the state, the Department of Health, and their position is, we paid it out. So how do you justify the extraordinary remedy of mandamus when the position is, we have paid, and now it's your burden? If you think that they haven't paid, if you think they've shortchanged you, that's on you to show that.
Okay, and
Why
that's
should they be doing a review? Their position is, I've paid, I've complied with the statute.
for the exact reason that Your Honor pointed out to me, because the statute says shall. The statute says shall reimburse 100%.
And that's what I'm saying, to their knowledge, they have done that.
Okay, and so in each of the instances, for those counties that were granted mandamus relief, they made an initial showing that, in fact, there was some reimbursement missed. That's the threshold. That's the predicate. We can't presume that all the counties weren't paid. So those counties make that showing. It is not then a stretch for those counties then to request the court to require the state to identify, to calculate, and ultimately pay. The third department is not telling the Department of Health how to do this calculation. It's only telling it that you have to do it.
Thank you, counsel.
Thank you.